Hi, good afternoon, everybody. My name is Rami Jurado. I'm an attorney here in South Florida, and I wanted to talk to you guys today about trademarks. But first, I want to share a couple of good news. Today, we received notice that we got 3 E2 visa approves. Those are the visas that you get when you want to be an investor in the United States, and we are super happy. And also that together with a fabulous CPA team, we were able to help our clients save $100,000 in taxes. So another amazing news, and we're super happy for that. All right, so let me get started. I'm going to share my screen right now. So trademarks. First of all, our firm, we're here in Miami, but we do help all over the United States when it comes to immigration and trademarks. So whether you're a U.S. company or a foreign company that wants to have a trademark in any of the states, we can assist you with that, or a federal trademark, which is what we usually recommend. We also practice in the areas of real estate law, probate, state planning, and all sorts of litigations here in the state of Florida. So let me start. So trademarks, basically, here's a little outline of what we're going to discuss. We're going to talk about the types of marks, the benefits of trademark registration, how do you go about selecting marks, requirements for registration, and dealing with the trademark examiners. And lastly, why you need to register with U.S. Customs once you do have your trademark. Start at the beginning. What is a trademark? Well, you can trademark a word, a name, phrases, symbols, and design. Anything that describes your product or service can potentially be a trademark. It's basically used to identify and distinguish goods or services from one person or one company to another, and to indicate that source of goods. Where did it come from? If it's known. A service mark is usually, it's just like a trademark, but it's something that is associated with services that are provided. So for example, if I were to register a trademark for what I do, legal services, it would be a service mark. Some more known service marks are AA for American Airlines, or McDonald's for the restaurant service. So those are service marks. So what type of protection, right? We're asking what type of protection is available? Well, basically the rightful owner of a trademark or service mark can prohibit others from using the same mark or another mark which is so similar in sound, meaning, or appearance that it would likely lead to confusion amongst customers regarding the source of products or services in connection with the mark that is used. In other words, having a registered trademark allows you to stop anybody from using that mark if you did it federally in the whole United States as it relates to your goods or service. Now, people think that simply registering in the Florida Department of State or in any state as a company that will stop you from, that will stop others from using that name. That is incorrect. Some people even think that having a DBA or doing business as or fictitious name will help to stop others from using that name as it relates to a service or product. That is also incorrect. The only way to have protection to stop others from using that name with your service or product is by registering a trademark. And my recommendation is to register a federal trademark, one that's going to protect you all over the United States, not just in Florida or in any other particular state. You basically will get protection all over the United States. Now, trademarks must be distinctive, right? So trademark law only protects distinctive marks. So, for example, arbitrary, fanciful, suggestive marks are deemed to be inherently distinctive, so they're going to get some protection. Descriptive marks such as geographic name, surnames are not inherently distinctive and can only be protected if they have shown to have attained distinctiveness through use, usually referred as secondary meaning. Whereas generic terms are unprotectable and can never function as a trademark. Once a word becomes generic, it has lost, its value for trademark purposes. So whenever you're thinking about what name can I use for my business, for my product, for my slogan, I would recommend trying to be arbitrary, fanciful. It could be suggestive, but not so explicit as to describe what it is, right? So for example, what do I mean when I say arbitrary? I mean, you use words that are in common use, but bear no relationship to the associated goods. For example, Apple for computers is something that you can protect, as we know now. But you cannot protect Apple for apples, right? So Apple for computers, you could protect. Suggestive, what do we mean by suggestive? Well, we say you suggest some type of quality or character of the associated goods, but not so explicitly that no imagination is needed to determine the nature of the goods. For example, copper tone for sunblock lotion. It's kind of suggestive, copper tone, but it's not telling you sunblock lotion. That is something that can be protected. Fanciful, for example, is composed of coined words, right? Like Xerox for photocopiers. That's something that can be protected. Descriptive, on the other hand, are marks that describe the quality or ingredients or characteristics of the product or services with which the mark is used, and those are probably not going to be able to be protected. For example, beef and brew for a restaurant, it's not going to be protected. Generic, on the other hand, also we have, it's a common group or class name such as beer, shoe, automobile, to which particular product belongs to. A generic term can never be a trademark, can never be a registered trademark. Why? Because you're using the word that means what you're trying to protect. Like I told you before, apples for fruits, you're never going to be able to protect that because that means you could stop others from using that word for that product or service, and you cannot stop others from using apple for a fruit. So no, it will not be protected. Now, in the United States, we have something called first to use. That is, the U.S. deferral registration is not required to establish rights in the trademark. Rather, common law rights arise from actual use of a mark, whether or not it's the subject of federal registration. Generally, the first to use a mark, either in commerce or to file an intent to use an application with the United States Patent and Trademark Office, has the ultimate right to use and register that mark. Now, while registration is not required, the fact that you do have a registration helps you establish that you're the owner of that mark. That is why registration is recommended. My advice is if you're thinking of using a name and you haven't used it yet, you can still protect it. You can file something called intent to use, and you file something with the United States Patent and Trademark Office, and you say, I plan to use this name for this particular service or product. That gets the ball rolling. It's assigned to an examining attorney. The United States Patent and Trademark Office has a bunch of attorneys that work in examining different types of marks for different types of services. So even if you haven't used it yet, you can file an intent to use. They will start analyzing your mark so that by the time you use it, you have saved up all that time and you can get the registration. Usually a trademark process is going to take at least 9 months. That is assuming nobody opposes your mark, and that is assuming the United States Patent and Trademark attorney also doesn't have an issue with your mark. So it's not like you register and that's it, it's done. It doesn't work that way. So why is registration recommended? Well, registration confers important benefits to the trademark owner. For example, there's a possibility of treble damages for infringement. If you have a registered trademark and somebody's using that trademark for your service or product, you can send them a cease and desist letter telling them to stop using it completely. And if they don't, now you can sue them for 3 times your damages. So that is amazing, but you will only get that with registration. Also, the fact that you register, the law presumes that you are the owner of the mark. And because we're going to do a federal trademark, now you have geographic coverage for the whole United States. Even if you're only using your mark in Miami, the fact that you filed and you register a federal trademark, now you have protection all over the United States, as long as you're selling in commerce. And something very important, after 5 years upon filing an affidavit of continuous use, you have incontestability, which is even a stronger protection that you get because you register a trademark, 5 years have passed by, and now you can file this affidavit and have incontestability. Of course, once you register your trademark, that doesn't mean you can stop using it. No, the only way to maintain protection on the trademark is to register, and you have to continue to use the brand or product. A lot of people are confused as to why they see the R with the little circle or the TM. What do they mean? When can you use it? Well, the register mark, right, that is the R with the circle around it, is used by trademark owners to give notice that a particular mark is registered with the United States Patent and Trademark Office for a particular good or service. You can only use it after federal registration has been granted. If they see you using it without a registered trademark, you're going to get in trouble. Even if a trademark application is pending with the United States Patent and Trademark Office, the R symbol cannot be used. You have to wait until you get the actual registration. Improper use of a federal registration symbol, if done with intent to deceive the purchasing public or others in the trade into believing that the mark is registered, is grounds for denying a registration of an otherwise registrable mark. I remember having a case with somebody that hired us to file a trademark, and we asked them for the specimen, that is basically the proof that the mark is being used in commerce. And he sent me a bunch of little bottles of vitamins with the R on them next to the logo. I told him, you cannot file this. You need to basically stop using all of this like ASAP, because you're lying. You do not have a registered trademark. And if I submit this as a symbol of, if I submit this as a specimen, they're gonna deny you. They're never gonna give it to you because you are using the R incorrectly. So do not use that. So what can you use if you don't have a registered trademark? You can use the TM symbol. The TM symbol is used by trademark owners before they obtain a federal registration for their trademark. The use of the TM symbol, while not required by trademark laws, can serve many useful purposes for a trademark owner. It gives notice to people that you do claim some type of ownership to that name, slogan, or logo, but you cannot use the R symbol. Only after you have obtained your registered trademark, even if the registration is pending, you cannot use it just yet. So when the trademark attorney, so whenever we file an application, this gets assigned to United States Patent and Trademark attorneys, they are going to use what they call the DuPont factors to analyze whether or not your mark should be registered. And there are basically 13 factors that are weighed in by them. And also when they send us something called an office action to where they say, no, we don't want to register for this or the other, when we respond, we also use the DuPont factors to argue why or why not it should be registered. In our case, of course, is why it should be registered. So one of the first factor they'll look at is the similarity or dissimilarity of the marks in their entireties as to appearance, sound, connotation, or commercial impression. Yes, you can register as sound also. They will also look at the similarity or dissimilarity of the goods for which the marks are used. They will look at the similarity of the channels of trade of the goods for which the markers are used, the sophistication of purchasers, impulse buying versus careful sophisticated purchasing, the fame of the senior mark, the number and nature of similar marks used on similar goods, the nature and extent of any actual confusion, the length of time under which there has been concurrent use without evidence of actual confusion, the variety of goods on which the marks is used, the market interface between the junior and senior users, the extent to which the applicant has the right to exclude others from use of its mark on goods, the strength of the mark, the extent of potential confusion, and any other established fact probative of the effect of use. So in other words, you may have a trademark that sounds similar to another trademark or, when you read it, but if you can argue, for example, that the people that would buy your product will not buy it at the same store because of their different economic status, or the people that would buy your product are more of a sophisticated consumer, or the way that it's sold, you can get very creative to basically argue that your mark should still be registered. I remember we had a case where we were registering a trademark for wedding dresses, and there was already another trademark issued for wedding dresses with the same type of dresses, with the same type of similar name. However, the other trademark was for used wedding dresses, whereas ours were high-end, designer dresses. And that is what we argued. We said the consumer that goes to the discount store to look for those wedding dresses will not come to the high-end wedding, stores that our dresses were being sold at. And we were actually successful. So it just depends what you can argue for the trademark, if it's different channels, and you will not know this at the beginning, because hopefully when you file, the trademark attorney at the United States Patent and Trademark Office just lets it go. But when they send you the office action, it's not time to freak out. It's time to think, how do we argue that your mark should still be registered? And that's something that, of course, we can assist you with. I recommend that everybody does a trademark search. Now, when we file a trademark, we do a very, very simple trademark search just to see if you have the same name registered already. But I recommend you do an extensive trademark search, because that's going to allow you to know whether you can register your mark or not, or at least give you an idea. So when we do an extensive trademark search, we search for registered mark, unregistered marks. We search for state, because every state has their own trademark office. So we do an extensive search, and then we'll give you a legal opinion as to whether or not we think your mark can register or what we think you should do. Obviously, it's not perfect, right? The United States Patent and Trademark Office has 6 months to analyze this. They have access to everything, and they may find something that we didn't. but it's usually very accurate. So if you're thinking about branding, coming up with a name, I recommend that you hire us to do a full trademark search so that we can give you an idea whether we think this mark can register or not, and then you can go forward. The saddest thing is when I have people in my office that have received a cease and desist letter from somebody that had a registered trademark, and they're telling them you need to rebrand, you need to do it immediately, because if you don't, we're going to sue you for treble damages. And that does happen. So it's better to do a search at the beginning. All right. So assuming that the mark, you started using the mark already, now we can proceed to registration, or even if you didn't use the mark and we did an intent to use, for you to actually get the certificate, we do need you to use the mark. But assuming that the mark is capable of registration, sometimes the United States Patent and Trademark Office will not let you register in the principal register. Instead, they will send you something called a supplemental register. And that can happen when your mark, it's a little bit more explicit as to what it is, and sometimes they'll do that and they'll say, we put you in the supplemental registry, but after a couple of years, you can show us how you've acquired distinctiveness and we can move you to the other registry. And also, it's very important that, supplemental registry is not a bad thing, because you eventually can go to the other registry, the principal one. But whenever we can be in the principal one, of course, that's the goal. So there's two ways to register a trademark. One is you're using the trademark already. So a person or company who is already using the mark in commerce files an application. This is based on use. The other way to register a trademark is something called intent to use. And this is what I recommend you do, even if you're not using the name, the brand yet, just because you want to start the protection process. So a person or company who has a bona fide intention to use the mark may file an application based upon this intention to use the mark. A registration will not be issued until the applicant has begun using the mark. So you will not get a registered trademark, but you will stop others from using that mark, because I represent a lot of chefs, and sometimes they come up with this cool name for a restaurant. And they're like, Romy, I really want to use this cool name, but maybe I don't do it now. Maybe I do it in 6 months or a year, but I don't want nobody else to use it, especially if it relates to their own personal name and they came up with like a nice spin on it. So we will file an intent to use, and then maybe later, a year from then, they get some investors, and then we go ahead and finish the trademark off once we start using it, but at least they already protected that name so nobody else can use it. When we file an intent to use and it goes through the process, then we have 6 months to file what they call alleged of use. Like, you have to say, I'm actually using it. If you don't do it within the 6 months, you could always file an extension. I think it's a maximum of 5 extensions. So you could be protecting it even though you're not actually using it, but there will be a limit on the number of extensions when you file intent to use. So when we file, what happens? Well, there is an initial review for both the intent to use and the marks that are being used, where the United States Patent and Trademark Office, the attorneys, will review the application. First, they will see, does it comply with the statutory requirements? And then they will see to determine if there's any grounds for rejecting the mark. In my experience, they always try to find grounds to reject it. So it is our job to come back at them and say, no, you should still let it go through. So what happens if there is a rejection? Let's say, well, if the United States Patent and Trademark Office issues an office action, then the applicant has to respond, usually through us. You should respond through an attorney, with arguments as to why the mark is registrable. A response is due within 6 months from the date of action. Date of office action. If you receive an office action and you don't respond within 6 months, then it's going to be deemed abandoned. We don't want that to happen. So if you, for some reason, file your trademark and you receive an office action, contact an attorney so they can review it and tell you what they can do to file a response so that you don't lose it. If the response is unsuccessful, then the rejection is generally deemed to be a final second office action. And you could, if you want, request for reconsideration within 6 months and or appeal. So that's usually what happens if you get a rejection. There is no rejection, which is what we always want, right? So then what happens? Then it's going to be published in the newspaper, which is called the Official Gazette of Trademarks, for 30 days. And it will allow 30-day period for anybody to oppose it. Anybody can file an opposition. And it's also subject to an extension period, okay? If opposed, if somebody files an opposition, then there's going to be an opposition proceeding in the Trademark Trials and Appeal Board, and they will determine who has the right to register the trademark. If there is no opposition, if nothing happens during those 30 days, then what happens? If you have an intent to use application, now we have to file to say that we are actually using it to get the certificate. We will get something called a notice of allowance, and then we have to file an amendment to say we're actually using it and then get a certificate. Otherwise, if you're actually using it, then we probably will get a certificate within a short period from that, after it has been published for opposition and nobody has opposed it. Renewal. You want to make sure that you renew your trademarks. It's not forever, right? So you want to make sure that you renew, you pay the filing fees. You again submit that you're still using the mark in commerce and all of that. You will need to submit a declaration of continued use, and it's per class, and we can help you with all of that so that you continue to protect your mark. It's not enough to just register it. You have to continue to use it, and you have to keep on renewing it. If you have a question regarding the identification, or if anything it's not clear with your mark, what we usually do is we call the examiner. We have a constant communication with the United States Patent and Trademark Attorney. We could also email them. They have manuals regarding goods and services, so we can work with them. It's not like a filing thing and you forget about it. It's called prosecution because you actually keep on working with the United States Patent and Trademark Attorney to see if they'll allow the mark to register. If you get an office action for a likelihood of confusion, which is usually the most common one, then what we try to do is we narrow the identification of the goods and services to distinguish the mark, and we show how through its components, sounds, or meanings, it's very different than from whatever mark they're saying is confusing with because it's registered. We can argue channels of trade. We sell here, they sell here. We could also argue that the customers are sophisticated where the other ones are not. We can get very creative in order to present a good response for an office action regarding likelihood of confusion. Now, you have to understand that also once you get your trademark, right, it's not the end all be all. You have to continue to protect your mark. How do you do that? If you see another business using your mark, you want to contact your attorney to send them a cease and desist letter right away. You want to make sure that they know that you have a registered trademark and they're conflicting with your mark, and that if they don't stop, that you're going to sue them, okay? You also need to file something with the USPTO if you're, with the United States Customs and Border Protection, if you're importing goods from other countries, okay? The United States has a law that they protect against that, right? So if somebody's trying to bring copies or simulates that the trademark registered in the United States, or something that shows that they did it in the United States, but in reality they did it abroad, you can actually, by contacting CBP, get them to help you stop it. So what do? Let's say that you have a registered trademark for selling purses with the name, with a really nice name. And then you find out that somebody's importing purses from China or wherever with the same logo. What do? Before that, as soon as you get your trademark registered for your goods, you should send it to that email, to that link that I put there in the website, or you can contact us. We will do it for our clients, letting them know the name, address, and citizenship of the trademark owner, the name and address of foreign persons or business authorized or licensed to use the trademark, the copy of their U.S. registration, and of course, they have a filing fee of $350 per class for goods or services. So that way, they will stop, that's what we want, any mark or any product containing that mark, since you let them know that you register it. Now, in practice, additional efforts are often required beyond simply recording the mark to encourage local customs authorities to search for and seize infringing merchandise. What I recommend people do is contact them. Let them know, hey, I did this purse with this brand, and I know that people are bringing it from this country or this other country, or I know that this company is importing it. The more information you give Customs and Border Protection, the likelihood they're going to stop and seize those products and basically stop the importing of fake goods, because you protected your mark. All right, let's see. I don't see any questions yet, but let me stop sharing my screen. My contact information is there. If you have any questions, you can please put it in the chat or in the Q&A. Registering your mark is very important for a business because the intellectual property that your business has is one of the most valuable assets that your business possesses. If you register a brand, or mark, you're able to license it. So that's another stream of income that you can have. I have drafted many license agreements because somebody liked the mark of my client and they want to replicate the same business somewhere else. It's not a franchise. They haven't franchised the business, but they simply want to use that mark to sell whatever products or service. And then my client can make money through doing a license agreement, which otherwise couldn't have happened if they didn't have a registered mark. I have also had situations where other people want to buy the registered trademark because they want to use it. And then that way, that's another stream of income. So registering your mark can help you really build your business, protect your name so that nobody can use it, so nobody's diluting your mark, and also you can license it or sell it. So in conclusion, having your trademark, I definitely recommend it. If you want us to help you, we can do it in all of the 50 states, and we could also do it federally, which is what I recommend because it will protect you all over the United States. And that's not the only thing we do. We can help you with the license agreement. We can help you with registering your company. We can help you with state planning, probate, real estate, and litigation as well. Our firm is composed of many multilingual attorneys in different languages. So we're basically here to help. Thank you so much for joining my class today. I like to make my classes fast and to the point. I will send everybody a follow-up email with the registration for our next webinar and with a copy of the PowerPoint and hopefully of the recording so that we can continue to be in communication. Thank you so much for your time.